Hello, Realtors. This is Taylor Oxendine with the Central Carolina Realtors Association, going over changes to CCRA Form 1 and 2, the contract of sale, and the lots and acreage contract. The changes have been made as a result of the NAR settlement. As you've likely seen, the State Association, SCR, has released updates to their forms and is currently doing trainings on these updates. CCRA members should be sure to attend and watch SCR's training on their form updates to understand the changes when commission is removed from the MLS in mid-August. Be sure to review the changes to SCR's listing agreement, buyer agency agreement, and compensation agreement to ensure you are properly compensated for your work. Today, I will go over CCRA's contract to sale. The exact same highlighted language can be seen in CCRA's lots and acreage contract. Beginning with paragraph 10, transaction cost. Note that 10A and 10B have not changed. 10B states seller will pay buyer's transaction costs not to exceed X. Buyer is responsible for any buyer's transaction costs exceeding this amount. If the amount seller has agreed to pay towards buyer's transaction costs exceeds the actual amount of those costs or amount allowed by lender, then any excess funds will revert to seller. Seller will also provide or pay for all seller's transaction costs. In order to give agents another option to have the seller compensate the buyer or broker, these following highlighted changes have been added as two options under 10B. First, 10B1 states seller agrees to allow up to X of buyer's transaction cost reference above to go towards buyer's broker's compensation. However, this provision is not applicable if the concession was advertised as broker compensation on multiple listing service. As the first sentence states, the seller can now choose to take some or all of the amount written in section 10B to be used to compensate the buyer's broker through seller concessions. Obviously, the number in 10B1 will never be higher than the number in 10B. Having the seller initial this section protects you and demonstrates the seller understands their money is being used through concessions to compensate the buyer's broker. The second sentence sounds familiar since it is essentially restating the NAR settlement requirement. At the moment of this recording, on July 22nd, 2024, no Midlands MLS will advertise commission on their platform after the mid-August deadline. CCRA has members across the state that use other MLSs, so different regions could potentially have different rules. Therefore, this sentence may never apply. However, 10B1 is not applicable if the listing came from an MLS that is not in compliance with the NAR settlement requirement on commission advertising. Of course, you as the agent or the broker should understand your liability when using an MLS platform that allows commission advertisement. In this specific scenario, Section 10 can no longer be used specifically as an option to compensate the buyer broker. Finally, 10B2 simply states seller does not allow any of the buyer's transaction costs referenced above to go towards buyer's broker compensation. If for whatever reason 10B is filled out, but neither 10B1 or 10B2 are selected, as stated in the above bolded letters, failure to make such a selection means that none of buyer's transaction cost referenced above can be used for buyer's broker compensation. Now moving to paragraph 22. Other terms. A simple statement was included which states not to be used for broker's compensation. As you are aware, the contract of sale is between the buyer and seller, not their agent. Commission or compensation should not be included anywhere in this other terms section. Since the buyer's broker is not a party to the contract, the buyer's broker might not be able to receive payment, assuming no compensation agreement was made, from a seller if compensation is not paid to the brokerage. Further, since the contract is a contract between the sellers and the buyers, a licensee could run afoul of license law if the licensee allows or creates an unreasonable delay in the closing of a transaction or acts in a manner which causes failure or termination of a transaction due solely to a dispute among participating licensees concerning the division of a commission. Therefore, the association recommends properly using compensation agreements, such as SCR Form 120, that are agreed and signed by the paying party, typically the listing brokerage, and agreed and signed ideally before an offer, but can be signed and agreed at any time. Separately, the negotiated compensation agreements and exclusive rights to sell greatly aid in the appearance of arm's length informed commission negotiations, which is the whole point of the settlement. There must be clear negotiated and not suggested or coerced commission structures. Finally, on the last page of the contract, as I've stated, the sales contract is an agreement between the buyer and seller. Consequently, we have added, for informational purposes only, above the signatures of the buyer and seller agent. You should still fill out the signature sections, but it adds an additional protection to clearly identify the contract as being between the buyer and the seller. So those are the changes made to the CCRA sales contract for the NAR settlement. The exact same language has been added to the CCRA lots and acreage contract. Again, please go to screaltors.org to ensure you fully understand the SCR listing agreement, buyer agency agreement, and compensation agreement, and even the SCR contract of sale. As SCR has stated, the listing agreement, buyer agency agreement, and compensation agreement are there to ensure you have enforceable contracts, ensure the buyer, seller, and you have a clear understanding of how commission will be paid out. Be sure to watch SCR's Austin Smallwood's YouTube videos on the SCR form updates to prepare yourself and your clients for upcoming changes. The CCRA forms are currently being formatted for zip forms, so stay tuned for an update on when our forms will be available for use. Be sure to contact CCRA or contact SCR's legal hotline for legal questions on the upcoming NAR settlement changes. Thank you.